So we are live.
Very good morning to all honorable participants, to the guest speakers. In the beginning, I tender my sincere apology for the delay due to the technical problem. I welcome on behalf of our academy and all the participants today's guest speaker, Professor Dr. G. Mohan Gopal sir, former director, National Judicial Academy, Bhopal. I also welcome all the honorable justices from Sri Lanka, Nepal, India, all honorable directors of state judicial academies and their co-directors, all honorable registrar generals of the high courts, registrars and their team members, all honorable principal district judges, principal judges, district judges, all my brother and sister judicial officers, public prosecutors, members of juvenile justice boards and principal magistrates, and students, and all other invitees. I also welcome my co-host, Sri Chetan Singh Shergill, who is conducting this program on behalf of the SCC Online. I also welcome Sri Karan Malik and Sanjay Kapoor and their team who are collaborating with us from SCC Online. It's a pleasure to arrange this webinar with such a eminent speaker. Honorable Dr. Mohan Gopal sir is well acquainted, well known to all of us, not only in India, internationally. He is former director of the National Judicial Academy, Bhopal. Sir's main area of work is the institutional framework of law and justice. With the kind permission of Honorable Sir, to save the time, I would skip some portion of introduction to keep it as possible, as far as possible. But one thing I would like to share, our academy's duty is like a mother. Very small thing, story I would tell. You might have heard it by changing some characters. A mother takes a boy. A boy is very obsessed with eating sugar. Some say it as a jaggery also. The mother is fed up. She takes the child to Mahatma Gandhi ji. It is said to be sometime in 1930 to tell him to give up the sugar. Gandhi ji asked him to come after 2 weeks. After 2 weeks, Gandhi ji says, "Boy, my dear boy, please give up sugar." Same story is repeated in all jurisdictions. Some say it happened with Gautam Buddha. Some say it happened with Ramakrishna Paramahansa. But my point is here, we have an eminent person like Dr. Mohan Gopal sir who can enlighten us. And our academy's role is that mother. So with this introduction, I would now request the guest speaker to take over the session and start his session. You may post your queries in the charts, which will be put up to the speaker. For your kind information, I have to inform that the session is being recorded so that it can be viewed by those persons who could not access it with assumed kind permission. We are recording it. Thank you very much. Sir, please.
I'd like to wish all the honorable judges a very good morning, and very good morning to the Maharashtra Judicial Academy and Mr. Yaralagada. And I'd like to begin by expressing regrets that for reasons beyond Mr. Yaralagada and my control, because of the system we are using, there was a lot of difficulty in getting onto it. We had a similar session 2 days ago where we got in instantly, but this system that was given to us today turns out to be problematic. So we lost half an hour of very precious time, and I'm very, very sorry about it. Let me begin by saying that it's a great honor and a great privilege to be with several of colleagues that I've interacted with for several years. But it's also a special honor to be with honorable judges from Nepal and Sri Lanka. And I will try to ensure that our discussions today are relevant and inclusive to all concerned. I would like to begin by saying two things. One is to say that my work is on how we apply theory to improve practice. I don't work either just on practice, and I don't work just on theory either. And a good example I use is to refer to the work done to produce the vaccine for COVID. The COVID vaccine is not produced by doctors and nurses who are on the front line, working with patients, treating them, and giving them relief, but they are actually produced by researchers. They are not researchers who are just doing abstract theory, but researchers who are actually producing solutions for the virus, for the COVID virus. And so the vaccine is produced by researchers. Why? Because the researcher studies the virus. But the researcher also has a responsibility to come up with vaccines that can actually be used and applied and can give relief. The doctor and the judge, like the judge, focuses on relief to the individual patient or the individual litigant, whereas the researcher studies the virus and understands the virus across different patients and figures out ways in which we can neutralize the virus. So researchers like me, we work on the virus of injustice, not only in India, but across the world. How do we understand this virus of injustice? In fact, John Stuart Mill and later Amartya Sen have tried to define justice by identifying what is injustice as something that we have to definitely fight and neutralize, like we have to fight a virus. So we want to understand and study the nature of injustice that we see and come up with solutions that can be applied on a day-to-day basis by judges and courts in order to reduce injustice and promote justice. So this is my approach, to try to see to what extent basic fundamental issues and fundamental concepts can be applied in order to improve the working, day-to-day working of courts and of course chaired and led by judges. Now, from the Indian Constitution's point of view, we have a very clear mandate for the Indian legal system set out in Article 39A of the Constitution, which says that the state shall secure that the operation of the legal system promotes justice on the basis of equal opportunity. So the two-word mandate of the Constitution of India for the Indian legal system, which I think is a universal idea, is that it should be promoting justice, and I think that's not exceptional. Maybe it's a little exceptional to have it in the Constitution itself, and therefore we have to. We know that the role of the court requires us to understand very fundamentally what is justice and how to promote it. And so that is an example of a fundamental concept which, if we apply, the question is, will greater clarity in understanding the fundamental concept of justice, which is dear to the hearts of all lawyers and all judges and all people, will it help improve the operational efficacy of courts? That's the question. I believe it will, but it requires some reflection and deep thought, and I think that's what we are going to do. The second question leading on from this is, for many years now, I've been working on Judicial Academy for 15 or 16 years now, since 2004, actually coming up to 17 years. The years are just flying by, and as director since 2006. But What I found when I went to the academy was that a question that is on the minds of almost all people in the country, in all countries everywhere, was not very much seriously considered in the academy. And that question was, why is it that different people get different, let's say in criminal law, different people get different kinds of punishment. Somebody gets 5 years, somebody gets 6 years. Why is it that some decisions, a very common question asked of me by non-lawyers is, why is it that a court gets reversed by a higher court? So who is right? There are two views here. Who is right? Can you simply say hierarchically that the higher court is right? In which case, why did the Indian Supreme Court reverse itself for example, in the famous emergency era case of ADM Jabalpur? So people are not clear why. So I asked some of the most senior and distinguished judges who I first met in the National Judicial Academy, judges of the Supreme Court, after I became the director of the National Judicial Academy, the same question. So they told me, Professor, it is because the facts vary from case to case. And therefore, when the law is applied to facts, obviously you don't get the same result. As far as appellate courts are concerned, they appreciate law and facts in a different way than and correct errors in appreciation of facts and law. So I told them, I said, why don't we try this in a simulation? And they agreed. And in their presence, we carried out a number of simulations where we had the same facts and the same law argued by the same people in front of a large number of judges in a simulation. And we found that we were getting sometimes 60% guilt, 40% acquittal. Sometimes we were getting different ratios, but sometimes we were getting close to complete agreement. That when the same facts and the same law were heard, all judges reacted the same way. Sometimes when the same law and the same facts were heard, judges reacted in a very different way. So we then clearly through this evidence, we established that we need to understand this. We established that in some occasions, in some cases, whether or not you have liability in a particular case is determined to a large extent by who the judge happens to be. And so we thought we should understand this better. This was what people assume, and we got evidence of that. And we also started to wonder, why is it that in some cases there is no disagreement and there is unanimity? So we started to explore this and this much more, and we shifted away from simply studying the law to understanding the processes of judging. And then we realized that one more thing, and then I'll stop with this introductory part. One more thing we realized was that the most important aspects of judging, according to Indian judges, to which the maximum attention is given in judicial academies and judicial training, is how to appreciate facts, how to decide what facts are proved and are not proved, how to appreciate law, and then how to apply law to facts to decide whether someone is guilty or to be acquitted, or whether there is civil liability or not. Now, how do we reconcile this with the fact that in industrial countries and in most democratic countries, this appreciation of facts and deciding whether facts are proved or not proved, this application of law to the facts to decide guilt or innocence or to decide liability, is actually done by 12 ordinary jurors, most of whom have had no legal education, no prior experience in a court of law, and no judicial training or experience. And this is such a sacred principle for them that they will never give it up. It is the option of the defendant in a criminal case to decide whether he should have a bench, as you know, bench trial or jury trial. So if the people are given the option of, we don't want 12 ordinary people to decide this case, they will not agree, because for them this is very precious. They prefer that to bench trials as a general matter. So why is it that the system as a whole and defendants prefer that legally uneducated, legally illiterate, judicially uneducated, judicially illiterate people decide on what we consider to be the most important thing, how to appreciate facts and how to appreciate law and apply it to facts and decide guilt or innocence, which I have heard judges say is a matter of learned judicial instinct, acquired through experience. It is believed to be a great skill, but yet that skill is considered completely dispensable in industrial countries. So are we putting the emphasis on judicial education and the challenge? Are we understanding the challenge of judging and the challenge of securing justice in perhaps not the right way? We are putting emphasis on what is the easiest part of that process, namely deciding whether facts are proved or not and applying the law that is given to you to facts to decide guilt or innocence. That's easy to do. That's decision making. That is judgment and decision making. There's a field there called JDM. We do that all the time. All of us do that all the time. That's why they can call in a bunch of lay people and ask them to do it. Decision making is easy, not difficult. But if that is the case, then what is the difficult part of securing justice? And the difficult part, I would submit, has to do with the technology of judging in a democracy, of understanding 5 very, very crucial basic concepts on the basis of which a democratic judicial system operates. And those 5 aspects are the Constitution and the law, justice, democracy, rule of law, and reasoning. This ordinary people don't understand. They can understand, but they're not trained to understand that. What is the Constitution? What is justice? What is the role of a court in a democracy? So important that Aaron Barak wrote a book called Judge in a Democracy. What is the rule of law? And what is reasoning? This is what I often refer to as the art, science, and craft of judging, around these 5 fundamental concepts. Now, this knowledge the layperson doesn't have. And the job of the judge and the job of the lawyers in the courtroom is not to make a decision on who is guilty and who is not, which any layperson can do. Not to decide what fact actually happened and what did not happen, which any layperson can do. But to make sure that this process is consistent with the Constitution, it secures justice, it protects democracy, and it is operated through the unique and special techniques and methodologies called rule of law and reasoning. And I found that these 5 concepts were and continue to be greatly neglected. They are the Cinderellas of judicial education and judicial training. They are not given adequate attention. Whereas these are the real areas of expertise for securing justice. So what we'll do today, with your permission, is we will explore these conceptually, and then tomorrow we will see how the application of these concepts emerges in 2 case studies. I will discuss the instructions to the jury in the George Floyd case. Very recent case, very famous case in the United States, because from the instructions by the judge to the jury, we can see how deeply the court is safeguarding these 5 pillars, which is its role. And the judge tells the jury, now you decide the facts. You decide whether the person is guilty or not. That I don't need to do. You do that. I cannot do, you do that. But I am here to safeguard these 5 principles: Constitution, justice, democracy, rule of law, and reasoning. Right? and how we can extract that from the practical working of a court in the United States in the form of a judge giving instructions to the jury in the recent George Floyd case. Second is I will discuss a very recent bail order issued by a Delhi Sessions Court, a very interesting and very interesting bail order, and we will see how knowledge of these 5 fundamental concepts helps the court to secure justice, and how without this knowledge it is not possible to secure justice, and the edifice of justice will come crashing down. So today we will examine these concepts a little more, and again, I'm not here to give you definitions of these concepts. I'm no one to do that. I'm just a student of law. But hopefully this discussion will help honorable judges to start taking these 5 concepts very seriously and studying them. There's enormous amount of material available on this, on the internet, in judgments, and to develop the art, craft, and science of judging in order to secure justice. So that's what we'll do today, and then tomorrow we will apply this in 2 case studies, and then we'll have a discussion. But before I do that, I start doing that, I would like to request Mr. Yaralagada to kindly get some feedback from the honorable judges on what they think are the practical challenges in securing justice from their point of view and their experience, so that we can have this discussion in the light of their own practical challenges.
Thank you, sir. I am yet to get the questions from the participants, but I can give you one example, sir. Just like we had some discussion yesterday with some, not some, sir, near about 500 to 600 judicial officers had discussed this issue, sir.
Yes.
That is, priority is to procedure, what is the role and what is the justice. Yes. So the question discussed was a vehicle was purchased on hire purchase agreement with finance from a banker, and the purchaser, without consent of the banker, sold it to third person.
Yes.
With an agreement, mutual agreement, that the third person will pay the installments. Since the installments were not paid, banker issued notice to the registered owner, and registered owner took a smart move. He lodged a FIR of cheating against the third person, and police now seized that vehicle. Now all the 3 are asking the custody from the magistrate, custody of the vehicle. Some are of the view that we cannot become mere recovery agents, and therefore we should not give the vehicle to the banker. The registered owner is the person who got the finance and purchased. Though he did not pay the installments, it is a civil matter. Magistrate in the interim custody should not be concerned about. Yes. And some said that the fundamental principle is that the vehicle should be restored to the third person from whom it was recovered. So yes. Here, I think that procedure was much emphasized instead of the substantive law. And this, why this variation between the judges? Some think that a bank is the right owner to get the custody, something that the buyer, something that the third person.
Yes.
Sir, please.
So that's thank you very much. That's a very wonderful example. And I think what it tells me, sir, is that the emphasis of the approach is on the decision, We are jumping to, as a matter of procedure, we are jumping to what should be the decision. We've seen the facts, and we are then quickly jumping to the question, should the bank have it or should the other person have it? Now, I'm submitting to you, sir, as we will see tomorrow when we go through the George Floyd instruction to the jury, the judge there is saying, look, this you decide. I'm not interested in this. He doesn't say I'm not interested in it. It's not my responsibility. So if you take that approach, when we discussed yesterday, when you discussed yesterday with the judges this question, frankly, they should be disinterested in the main question that they actually focused on, namely, who should get custody of the vehicle. Because that is a decision that common people can make. But what a judge is specialized in, what the art, craft and science of judging requires lawyers in the room and judges, the legal profession to do, is really focus on how do you reach that decision, not what the decision is. It is like when we are taught mathematics or science. I have my bachelor's degree in science like hundreds of years ago, but the emphasis is not on the right answer or the wrong answer, sir. It's the process by which you reach the answer that is important. So we find that when we are acting really like jurors, we are doing the easiest thing to do, which is to decide it and then find some rationale for it. Whereas we are not emphasizing the process by which we reach that decision and the fundamental concepts on which that process of legal reasoning is made stands. And that neglect is leading to inconsistency of approaches. Because that's the only way we can get consistency. Consistency cannot be in the decision, in the outcome of the decision. Because that, as I said, is not part of the art. Decision, I would go as far as saying that in the classical models of modern law, except in a bench trial, the decision on the final decision on proved facts and liability or guilt is not part of the judicial decision-making process at all. The judicial decision-making process lies in these other 5 areas that I talked about. And that's where the debate should be. And if we have a science and a craft on that, then we'll find that automatically, because I'll get into that, by the nature of that process, there will be much more consistency in approach to decision making. We are not looking for consistency of result. We are looking for consistency of approach. Now, if I go to a doctor and I say, my shoulder is paining, just fictitious, it is not, but in hypothetical, but my shoulder, and I go to a cardiologist, then one cardiologist may tell me you must have a surgery, someone else may say don't have a surgery, but their methodologies will be the same. The authorized tests they will do, the way they will interpret the tests, and they will also give you reasons for their conclusion so that they can actually talk to each other and say, look, there are 2 rational options possible. You have a surgery, you don't have a surgery, and this is what you can do. Here are the risks and benefits of each of this. Now, I'm not saying what judges decide or courts decide, lawyers and judges together, are like medicine. It's not like that. But we should also have much greater consistency of approach to judicial decision making, and that is at the heart of securing justice. Justice is not simply a decision. Many judges in our country tell me very often, we have to go beyond the law to secure justice. And that tells me they're acting like jurors. They are not even jurors, because even jurors are instructed by this process, but by lay people who think if these are the facts, this is justice, and the law is coming in the way. And they are not actually working within the framework of securing justice, the methodologies of securing justice, which is what we need to focus on. The other practical difficulties in doing this, we will discuss tomorrow, which includes court management. Do we have time to, sorry?
Sir, I have 2 queries I can put up.
Yes, sir.
One is, sir, sir, you have not just spoke about what are the important things, that is the law, justice, democracy, rule of law, reasoning. So these you have spoken, sir. So the query is, if a case is clear on applying first four principles, as you have said, sir,
Yes.
is it required to give reasoning in detail
Yes.
by
Yes.
writing too many paras or pages?
Yes.
That,
Yes. Yes.
that is one thing. And second thing, sir, sometimes it appears that while imparting complete justice, we trial judges need to mold the law, or
Yes.
sometimes law is not much helpful. Can I repeat, sir?
Yes.
It,
Yes.
it appears that while imparting complete justice,
Yes.
we trial judges need to mold the law,
Yes.
or sometimes the law is not much helpful.
Yes.
So what to do in such situations?
Yes. Yes. So the first questioning is reasoning, is reasoning necessary? And the second question is basically what I was saying, that can you go beyond the law to do justice, to do complete justice? Can the law be molded to get complete justice? So see here again, my submission is both these questions give too much emphasis to the jury function. Namely, what is the decision? What should be the decision on this case? Liability or no liability, guilt or acquitted, guilty or acquitted. So the first problem is we have to ask ourselves, what is the responsibility of the judge? Is it just to decide and dispose of the case, or is it something else? Is it to uphold a system of thinking and arriving at a conclusion, and letting that system of thinking lead you to a conclusion, rather than be indifferent to that system of thinking, or be inadequately educated on that system of thinking, sophisticated about that system of thinking? Right. So that is where, sir, I think we should.
Sir, one more short query, sir.
Yes. Yes, sir.
This pertains to family court, may be extended to other courts also.
Yes.
In family matters, the courts are supposed to deal with discretionary jurisdiction.
Yes.
This is because every case is unique. It becomes a tough job to use this discretion. Please guide us.
Yes. So we'll come to that also. What does discretion mean? And discretion does not mean that the subjective, that the rule of law rules out an understanding of discretion that is a subjective decision making of a judge. So what we can do, sir, is we can start exploring these fundamental concepts and then come back to these questions and see how they are applied. So today will be a little conceptual, because it is like understanding, for example, let me use an example I've used in the presence of Mr. Sudhakar earlier to another audience, and that is, let's understand how a plane flies.
Fine.
Now, we can, as passengers, simply say, I want to get to Delhi or Colombo or or Bombay. Or we can try to understand not the destination of the plane, but how the plane flies. And if you're a pilot, you cannot get to Colombo or Kathmandu or Bombay unless you have a good understanding of how the plane flies. And the plane, as you know, sir, as you know well, and we discussed the other day, there are four forces that makes a plane fly: lift, thrust, drag, and weight. Lift, the air lifts the plane up; thrust moves it forward, and there are two counter forces that the plane uses in order to move where it wants to move: drag, resistance of the wind, and the weight, the gravity. Now, it's unless you understand these four forces, you cannot take the plane to its destination. If one of these forces fail, the plane will crash. I would submit to you, sir, that these 5 forces are what keeps the system of justice in the air. The Constitution, the idea of justice, the idea of democracy, the idea of rule of law, and the idea of reasoning. They are as important to keeping the judicial system afloat as the ideas of lift, thrust, drag, and weight, which we passengers and even the pilot can neither see nor are aware of. They're just looking at the schedule. When is the coffee coming? When is the drink? When are the snacks coming? Soft drinks coming? And then you're moving to your destination. But actually, what is taking you there are these four forces. So similarly, the 5 forces that keep the judicial system afloat are these 5 forces. And if you don't have them, they will crash. And this is what I refer to as the physics of justice, the physics of justice. And so we need to understand that. So I think, sir, once we get into, you'll find that discretion, as this question implies, has no place in this physics, sir. This is like saying, does the pilot have discretion to ignore gravity and pretend he's in outer space? Pilot has discretion, a lot of discretion. Lot of these, sir, when I talk to pilots, because of this interest of mine, I've actually talked to pilots, and they say that once in a blue moon, completely unexpected events happen. Completely unexpected events happen. And there's nothing but their personal judgment that decides whether the plane crashes or survives. And they usually have a split second to make that decision. One Air India pilot told me he was flying back from the United States to India, and he was having breakfast in the morning, but suddenly he found that a fighter plane of maybe the United States or some other country was flying directly at him. And he said, I had a few seconds, maybe less than a second. I threw the breakfast tray off my lap. It went flying all over the cockpit. And I immediately altered the altitude and course of the plane. And that jet just zoomed inches past this commercial aircraft. Pilot error may be on the other side. But this pilot saved lives that day, sir. But he has no discretion to ignore gravity. He has no discretion to ignore weight. He cannot think he's driving a small glider plane. He's driving a 747. It has a certain number of passengers. It has a certain weight. He has to work within that. He cannot ignore thrust. He cannot ignore lift. Similarly, sir, a judge cannot work outside the Constitution, outside justice, outside democracy, outside rule of law, and outside reasoning. Within that, yes, there is a lot of judgment, not discretion, judgment that has to be made about how these forces have to be managed and to what end and to achieve what purpose. And the two main purposes, or one main purpose, is to ensure consistent justice across the country. Whether you are in India, whether you are in Kerala, where I'm speaking from, I divide my time between Delhi and Kerala. I'm now in Kerala, which is the farthest away from Delhi of all the state capitals, in Trivandrum. Whether you're in Trivandrum or in Srinagar or in Ahmedabad or in Guwahati, the 4 corners of our country, 4 towns. When I walk into an Indian court, I must have a consistent approach to justice. And justice should not be whimsical. And it should not be, and I'll come to why we found that in some cases there is consistency. There is consistency. It's not that in all cases it varies by judges. In many cases it does, but in many cases it doesn't. We need to understand why. And we need to ensure that we get consistency in securing justice. substantively. Okay. So this is, so let me jump in, sir, because we have we are running out of time. But I would like to know if the honourable judges from Sri Lanka or Nepal have any questions they can pass on to you. I wish we had a platform where we could have just had a discussion, sir. It would have been wonderful.
Sir, we have questions are near about 10 to 15, but again, the same thing pertaining to, as you said, sir, we will take up later on after your session is over.
Yes, sir. Yes, sir.
We can take up them, sir, because we have tomorrow also.
Yes,
and
yes.
we can summarize these questions and put up in a ordinary.
Yes, yes, sir. Thank you very much.
Please, sir, go ahead. Sir.
Now, I would like to also, before I get into this, I want to know, when do you want a break, sir, at some point, and when?
Sir, I think now it is 11:05, so at 12 o'clock we will have a break, sir.
Okay, sir. Okay, sir.
As per your, yes, sir, as per your convenience.
No, sir, we can. I think maybe like 11:45 or so. So there is. Otherwise, the first session may get a bit too long. And
yes.
Then we can come back at 12 and continue till 1 o'clock.
Yes.
So okay, now I'd like to pick the first. So I've made the first point I have made is that our objective of all the courts is to secure justice in a consistent manner. And I've made a second submission that the challenge here is not to get the decision correct, because we have done hundreds of simulations that show that there is no agreement within judges on what is the right decision. As Mr. Sudhakarji also has pointed out today, there is no consistency on what should be the right decision. So that's not, so we have to shift our focus away from decision to the method of reaching that decision, which is what courts generally do and which I refer to as the art, science and craft. Please note, sir, that I'm using the word art also, because then there is a lot of room for creativity, like the judge, and and deeper understanding. So we have to shift it away. That's my second point, away from simply focusing on the decision and disposal of the case or settlement of the dispute. What is acceptable to the parties? I find that from Supreme Court downwards, a lot of judges feel that their job is to settle a dispute. And so they'll say, okay, what is, like, although it was intended in a very different way, one of the Supreme Court judges controversially, and it was, I think, somewhat taken out of context, but still it was, in my view, not the right question at all, where, in a rape case, the question was asked of the lawyer, will the rapist marry the victim? Very wrong question, but it is impelled by this anxiety to settle the dispute. And so the court as dispute settlement agency, court as decision maker. What is the job of a judge? He has a task. He's like a collector. He's like any bureaucrat. He's got a set of rules. He's got issues before him. He's got to, it's a task that has to be done as required, and you get a salary for it. That's the second view of understanding judges. In both these things, there's an anxiety to reach a judgment, settle, dispose of the matter. But actually, if we understand the concepts of constitution and justice correctly, we will start to see a completely different role for courts and judges, which we will come to at the end of our discussion. So let me now start with how do we understand the constitution? Again, I'll be brief because I want to finish one or two of these concepts before the break, and then a couple of concepts after that. So how do we understand the constitution is a very important question. At one end, people understand the constitution as nothing but a set of rules, supreme rules, the suprema lex, which overrides other statutes and allocates power, creates organs of the state to which power is allocated and regulates the exercise of that power. Now, this is not wrong. This is not wrong. But that is not what basically, certainly the Indian constitution is, and I would argue no constitution is like that. That is why in some, as you know well, in some jurists refer to the constitution using the concept of Grundnorm, the basic norm. Norm means a value of conduct, which distinguishes right conduct and wrong conduct. So when you say constitution is a Grundnorm, you're basically saying it is a basic value of conduct. And that is important because the only issue with which the legal system is concerned, the entire legal system is concerned, is whether human conduct is right or wrong. And if it's wrong, what the consequences are. Only a human being goes to a court and can only go against another human being. Other fields of activity, like medical scientists, are concerned about the virus. Virus is not a human being. They've got to study viruses and attack bad viruses. But lawyers in the legal field and judges, we are concerned only about human conduct and only about the rightness and wrongness of human conduct. And we do it in order to uphold the mandatory rules of conduct which are imposed in relation to the most important values of human conduct, not the least important values of human conduct. And therefore, if those fundamental rules of human conduct are not maintained by the legal system, society falls apart, as many of us fear is going on in different parts of the world from time to time. And so the courts and judges have a very special responsibility to uphold the right rules of conduct. That's why the Constitution is referred to as a Grundnorm, a norm meaning a value of conduct. Now, we recently had a very interesting judgment, which Mr. Sudhakarji can share if he wishes with the participants, by Justice Ravindra Bhatt in the Supreme Court of India, February 2020, where Justice Ravindra Bhatt, the Supreme Court of India, actually formulates a very new and very different understanding of what the Constitution is. And Justice Bhatt says that the Constitution is an agreement, a compact. He uses the word C-O-M-P-A-C-T, compact, an agreement between people on how they will treat each other. I think that's a very remarkable and very insightful definition of a constitution. So a constitution as an agreement between the people, not something imposed on the people. We, the people of India, begins the constitution, like in the United States Constitution. We, the people, are agreeing, not imposing, agreeing with each other on how we should treat each other. And in that judgment, Justice Bhatt gives a lot of importance to a very neglected part of the basic framework of the Constitution, the basic structure of the Constitution, that is fraternity, the idea of fraternity, friendliness, friendship. And he says, look, basically what the people of this country agreed is that we will treat each other in a friendly way, fraternal way. For that, we must respect each other's freedom. We must respect each other's equality. We must respect each other's dignity. Someone who does not respect my dignity, someone who takes away my freedom and treats me as an inferior, is not my friend. That's not friendly behavior. So Justice Bhatt says that basically, I'm not using his words, I would say that he sees the Constitution of India as an instrument of establishing friendly relationships between people. and gives us a guide for that. Now that guide is a very interesting guide, because there's a lot of conflict in society, especially in our country, huge conflict. We are 1,300 million people. Very diverse in every possible way. Lot of scarce resources, lot of poverty, massive lack of basic resources for the people of this country, dehumanizing poverty. So naturally, there's a lot of conflict. Now, how do you resolve this conflict? How do you create friendly relationships in such a context? This is a very practical question for administrators and for judges. And here I find Justice Bhatt's judgment very helpful, because he's refocusing our attention. This is not simply an administrative document. That's why we don't consider constitutional law a branch of administrative law. Constitutional law comes from the word constitution. And Justice Bhatt is telling us a constitution is a compact, an agreement between the people on how to establish a friendly, caring society, a set of friendly relationships with each other. Now that is also interesting, very briefly, because if you take the Indian Constitution says, right, we the people of India, having solemnly resolved to constitute India into a republic. Now, constitute means to put something together which doesn't exist. They did not say, we the people of India, having solemnly resolved to continue India as a feudal society, or to revert India into its past. They use the word, we have resolved to constitute India into a republic, which it is not. If it is already a republic, you don't need to constitute it. It already exists. You only constitute what does not exist. So we the people of India, whatever our past was, of an India that was feudal, that was always ruled, except in Buddhist times, according to Dr. Ambedkar, when we had democratic social order, according to Dr. Ambedkar. We were always ruled by monarchs, whether British monarch or Mughal monarch or the monarchs of our own soil and our own production, whether they were from our soil or not, but monarchs who emerged here. So they didn't say we are going to continue monarchy and feudalism. They said we have decided to constitute India into a republic. The word into is very important also, which is democratic. And we'll come to this meaning of the word democratic later. But Justice Bhatt in the Supreme Court says that the heart of this compact of the people of India is to create a fraternal society with fraternity and friendship between each other. So we see the Constitution as an instrument to establish friendly relationships between people, which can be done in two ways. One is by upholding principles of conduct that are conducive to friendly relationships, and second, by deterring and opposing values of conduct which are inimical to friendly relations. So coming back to the question, how do you deal with conflict when there is such a lot of conflict in our country? And there, I think a lot of experts in conflict resolution say that the way to resolve a conflict is to find a common ground between people, which they cannot reject, And what the Constitution tells us is that, gives us is a set of common principles of conduct that no one can reject in this country. High-level constitutional principles. So I can disagree with my neighbor over whether I can take extra water from the well or not. I can tell my neighbor can tell me you are from an untouchable community. You cannot touch the well, water in my well, and I can say, well, that's correct, and so but I don't agree with that. That's your view. That's not your view. That may be your view, but I don't accept it. It's a common well. It's public resources, and I want to use that water. Now, at the level of can a untouchable use water, used also by the upper caste, is an issue on which the upper caste and the untouchables disagree. And we've had violent conflict over this. People have died over this particular issue. But when you elevate this issue up to the principle of fraternity, which is in the Constitution, and you ask the upper caste and the untouchable the question, can we survive unless we live together and work together? Then they will say, you're right. We must have, any rational person would say, we have to live in friendship. And then you say, can we live in friendship unless we respect each other? You respect my concerns, I respect your concerns. And then we say, that's what we mean by equality. Because you respect each other not because I'm rich and educated and powerful. You respect only because I have something in me which is the essence of, I'm a human being. I have the essence of humanity in me. You have humanity, I have humanity. This was not created by us. This was not given to us. It was not earned by us. We did not work for it. We were born with it. And because we value our own species, we must learn to respect each other's humanity equally. You don't have a few ounces more of humanity than me. We all have the same humanity. And if we have to live together with fraternity, we must have mutual respect. And if we must have mutual respect, we must have equality. And equality, frankly, gives nothing, it means nothing more than giving equal and highest value to the humanity of all human beings, and giving all other features of human beings like power, wealth, knowledge, skills, much less value, only contextual value. But there's only one overriding value for us, and that is the essential humanity of people. That's what equality means, that we treat each other, first of all, as equal human beings. And then suddenly we realize that unless we respect each other, we treat each other as human beings, and we oppose ideas that deny that humanity, we will not be able to coexist. We also say that without liberty, without freedom, you want freedom, I want freedom, and unless we respect each other's freedom, we cannot live in friendship, because the moment you start taking away my freedom, there will be conflict. So the Constitution has given us, and similarly dignity. Look, you're telling me I can't drink water because I'm an untouchable. You're attacking my dignity, my self-worth, my self-respect. And if that is the case, then we cannot live together as friends. So the Constitution, as an instrument of creating a friendly society, has established 4 core values that are necessary to have a friendly society. The commitment to friendliness, fraternity, first. The commitment to equality, because friends respect each other, simply because they're human beings. And a commitment to liberty, because friends are not people who take away each other's freedoms. And a commitment to dignity. And a philosophical framework of society, which we call democracy. Democracy comes from 2 words. We'll come back to this later, but it comes from the word kratos, which K-R-A-T-O-S, which means power, and demos, which means common people. So the principle that brings us together is that power shall be held by us, not by some ruler. So these 5 core cardinal principles together together provide a framework for us to live in peace with each other, because I don't want to see you slaughter my children. I don't want to see my children slaughter your children. So let us live together in peace. So when we elevate issues to these 5 accepted principles, we have a basis to create a friendly relationship in society. We have a consistent task across the country to convince people about the invaluable, the precious importance of these 5 values to keep us together. That's what the Constitution gives us. So we understand the Constitution as an instrument to establish a friendly society, as a basis for friendly relationships between people. And then the Constitution asks itself, how do we do this when there's so much conflict in this country? So they say, okay, we can do this by lifting, elevating. This is like to go back to the physics of justice. Lift like a plane lifts. Lift it to these 5 values of human conduct. How we treat each other. We treat each other on the basis of equality, on the basis of fraternity, on the basis of dignity, on the basis of liberty, and committed to equal sharing of power, which is the basis of democracy. So no one can disagree. No one can disagree. No rational person can disagree that these 5 principles are necessary for people to live together in peace, wherever you are in the world. This is not Western, Eastern, Indian, Sri Lankan, Nepalese. This is human. This is the lesson that we have learnt as humanity through thousands of years, distilled and given to us in a language that may now, we are speaking in English, so we have to use these values, these words. But there is one other word I will add to it, which is comes from our freedom struggle and informs all these 5 values. Very important to us in India, and I believe in Sri Lanka, and I believe in Nepal, and I believe in Pakistan, and I believe in Bangladesh, I believe in all these countries in the Indian subcontinent. This 5th value is most important, which is not adequately emphasized in the jurisprudence of other countries, and that is the value of compassion. Anukampa, Karuna. When Muslims pray 5 times a day, they're praying to God, the beneficent and the merciful. The Christians consider God an embodiment of compassion. The Buddhists, the Jains, the Hindus, we all believe in Anukampa and Karuna. Very, very important for us. So for us to have a friendly society, we need these 5 values, which are universal in nature. Anukampa is also universal in nature, but it is probably because of the long traditions of all these religious traditions, 5 religious traditions in our subcontinent, all of which agree on the importance of Anukampa and compassion. Very important to the people of this country. That's where the principle of non-violence comes from in the Indian experience, from the principle of Anukampa. When Anukampa informs also these 5 values, then we have a fantastic framework for building a friendly society. So ultimately, a judge is sitting in the court in order to promote values which will establish a fraternity in our country, in the words of the Supreme Court, or in layperson's terms, which will establish a friendly society, a society where people care for each other, and a society in which the relationships are friendly. And that is the meaning of the word fraternity. So we understand, the first point is we understand the Constitution in this manner as an instrument to promote and establish a friendly society. Now I come to the word justice related to this, very important word. Justice, as many of you know, who have heard me before, I've been repeating ad infinitum, that the word justice comes from the word JUS. Yes, sir. Yes, sir. Yes, sir.
Can you include the social justice also?
Sir, that will, I will bring it within the concept of justice, sir.
Yes, sir. Yes, sir. Thank you, sir.
Thank you for the timely reminder, sir.
Sir.
I find that Sudhakarji is a very highly wonderful chair or anchor of these discussions. Sir. Very timely. Thank you, sir. So the word justice originates from the word use. I'm sorry I'm talking so much. Normally I like to be interactive, but this platform doesn't give us that option of directly speaking to each other and interrupting each other. Sudhakarji is, of course, wonderful to stop me whenever necessary. So justice comes from the word J-U-S, which is pronounced, as you know, as use, as if it is Y-U-S. To all of us in the legal profession, this is probably the single most important word, technical word, which a lot of jurors may not understand, although they're called, the juror also comes from J-U-S, but they don't understand the meaning. The first thing any judge needs to know is to really deeply understand and reflect on the word use. It is a root of the word judge, J-U-S plus D-E-C-I-R-E, decire, is the root of the word judge. So what does use mean? What does use mean? Use basically means the right value of conduct, the right norm, not of conduct, the right norm. We'll get to conduct in a minute. The word use means the right norm, the right value. So I can tell a judge your decision is just. It means that your decision meets the right norms. I can also tell someone in a coffee shop, I want just half a cup of coffee, just half a cup of coffee. I'm using the same word just. Why am I using that? Because half a cup is the right norm. People don't realize that when they use this word. But whenever you use the word use, you're denoting that there is a right norm. You're reminding people when you say, this is not just, you're saying this does not meet the right norm. When you say this is just, you say this meets the right norm. And therefore, what we are doing when we discuss justice is, we are actually focusing on the question, what is the right norm? Now, in the context of law, the word use means right value of human conduct, because as I said earlier, the legal system is only concerned with human conduct. And therefore, when we talk of use in the legal context, we mean only right value of human conduct, not right norm of how much tea I want. Only right value of human conduct. That's our only concern as a discipline. Now, what does justice mean? Justice is a combination of the word use, J-U-S, plus the word S-T-I-C-E. S-T-I-C-E actually means still, not moving, unmoving, not moving, still. So we refer to solstice, sol meaning sun, as in sun and moon, and stis meaning standing still. So we find that in summer solstice and winter solstice, the sun moves, comes to a halt, and then moves back. When it stands still, we say that's solstice. So stis means use is standing still. Now, Amartya Sen has discussed this once or twice in his book and in one or two other articles, where he has discussed it also with Quine, one of the leading philosophers of the United States. And they, in my humble view, went on a wrong track and said, does justice mean the law has come to a standstill? And it can, and they did not take it further, because I think they did not really remember or apply their mind to the real meaning of the word use, which is not law, but a standard of human conduct, a value of human conduct. And therefore, if you combine use with stis as a standing still, you say that justice means those values of human conduct that stand still, that never change, So justice means eternal values of human conduct, eternal values of right human conduct. So we say justice prevails, or justice has been done when actual human conduct in a fact pattern is consistent with these eternal values, values that never change, that stand still. So we say when these values crystallize into actual human conduct, then we say there is justice. Why? Because actual human conduct is in line with eternal values. We say justice shall be secured means we shall ensure that the conduct, the right thing is done. We say there is injustice, meaning that human conduct is not following the right values, the eternal values. So the second point, the first point I made was to say the Constitution should be understood according to the 2020 February judgment of the Supreme Court as a framework for establishing fraternity or friendly relations amongst people, established by the people themselves. That framework, those norms, the agreement on those norms have been entered into by the people with each other. So now we know that the Constitution has established has established a republic based on an agreement between people on maintaining friendly relationships. We now know also that justice refers to the right values of conduct, not today's value or tomorrow's values, but what is right forever, what does not change, unchanging right values of conduct. Therefore, justice becomes necessary to ensure that relationships are maintained on a friendly basis. An unfriendly behavior is treated as injustice. So justice is a codification of what we believe is the right conduct necessary to maintain fraternity and friendly relationships between people. Because justice simply refers to the right values of human conduct. And therefore, in my argument, in my work, I say justice, if you ask not the content of justice, but what is it? Then I say it is a standard of human conduct. It is a standard of human conduct. But what is its content? Its content is right conduct. The definition of right conduct, the values that constitute right conduct. That is justice. So, if justice is the values of is a set of values, a standard of right human conduct, we have very different approaches to what is right human conduct, right conduct by human beings in India. So how do we resolve these differences? I told you before that the technique of resolving differences is to elevate, to lift it to the highest level that is acceptable to everyone. And that's what I said, I argued that the Constitution does. It has distilled 4 very clear values, and I read into it a 5th value, and those 4 clear values are fraternity, the value that relationships and human conduct must be friendly. Another word for it is social, because socius also means friend. SOCIUS means friend. Social means friendly. Antisocial means unfriendly. So the first agreement amongst the people of India, in the words of the Supreme Court in February 2020, the first element of that compact is that we shall maintain fraternity. We shall maintain friendship with each other. And the second element of that is that we shall respect each other. So you have equality and dignity. We shall give equal value to our humanity, ignore all other factors, and respect each other's dignity. So we have fraternity, equality, and dignity. We shall respect each other's freedom, because we all want to be free. That is liberty. Except if you take away my freedom, I'll restrain your right to take away my freedom, nothing beyond that. And finally, we accept that we shall share power equally amongst us, that we, the demos, shall exercise kratos, and that is democracy. I also argued that there is a fifth implicit element that comes out of our freedom struggle and of our long and ancient history across the entire subcontinent, and that is that we shall be compassionate to each other. Compassion means, anukampa means, kampna in Sanskrit and Hindi means tremble, tremble. Anukampa means that when you have pain, I tremble because I feel that pain. It is not sympathy. It is not you feel pathos, I feel pathos, we both feel pathos. That is sympathy. This is empathy. You have pathos and your pathos is inside me. Your pathos, not my pathos, is inside me. Anukampa, that I feel your pain. So these five values together are the values, the core values of right conduct, the Grundnorm, which we call justice, constitutional justice. Constitutional justice. And when we say in Article 39A that the operation of the legal system shall promote justice, we mean that the legal system of the country shall promote, safeguard, secure fraternity, equality, dignity, liberty, democracy, and I would add compassion, anukampa. So then when, as we will see when we turn to the practical applications of these principles in actual case law, in a recent Delhi Sessions Court judgment and in the instructions to jury in George Floyd, and you can see the difference of the fifth factor, the compassion that is there in the Indian judge, which you may not find. I'm sure compassion is there everywhere, but compassion is part of our much more visible part of our conscious thinking than it is I have found in many other countries. I've lived in the United States for many years. I've taught law there. I've worked there, and they are very compassionate people. They're very compassionate people. But our formal frameworks can and should recognize the idea of compassion more than they do. But we will see tomorrow in the practical application of these ideas to practical cases in the George Floyd case. The reaction of the public to George Floyd was pure compassion, pure compassion. People felt the pain of George Floyd. There was a young girl whose videotape became the most crucial part of the evidence against the police officer who killed George Floyd, a young girl. And she was crying on the witness stand, saying, every night I'm apologizing to him that I could do nothing to save your life. Yes, I taped the way you were killed, but I could not stop it. She feels his pain in herself. That is compassion. So all human beings have enormous compassion. Our challenge is how can we bring this compassion into a framework of decision making in courts, and should we? So that's a separate area. So what I'm arguing is Constitution should be understood, in the words of the Indian Supreme Court, new words of the Supreme Court in February 2020, but not a new idea, as an agreement amongst we the people of India to establish fraternity, friendly relationships in our country amongst people. And as I said, in a country full of conflict, that can only be done by invoking the power of the highest values that no one, no matter what your caste, creed, religion, gender, wealth, assets, power, no one can deny the validity of these values. And those values are these five values that the Constitution of India provides to us as a basis of a society based on fraternity. And the job of the Indian legal system and of every judge in every decision they make is to make sure that they inform the people of the country, the parties before them, and the society in which they live and work, the larger society, that by taking this decision, I am sending a signal that fraternal values are accepted and valued in our society and inimical values are not approved in our society. So if you punish someone whose the values that you're judging are actually fraternal values, you're going to weaken the Constitution and you're going to weaken the Republic. If you let someone go who has clearly been antisocial and anti-fraternal and inimical in the values that he practiced, and if you allow and respect those inimical values of hatred, of anger, of violence, then again we will be damaged. We will be fatally, mortally wounding the Republic. So every decision we make, the outcome must be guided by this vision. So when we go back to the example that Mr. Yaralagada gave us, the question to be asked is not who should have the car. The question to be asked is, what is the value that should guide this question? Now, everyone knows that the financial system and the economic system operates, economists will tell you, operates on the basis of trust and expectation. So fraternity, the value of fraternity requires people to be able to trust each other and rely on the legal agreements they make. And therefore, we bring into that ideas of, certainly bring into that question the ideas of the relevance of fraternity as a value, and the economic system being very much a central part of having fraternal relations, the importance of the value of trust. There are two issues of trust here. The bank trusted the nominal borrower. The nominal borrower trusted the third party to which the obligation to repay the mortgage was assigned. Two levels of trust going on here. Where was the betrayal of trust here? How can we create an outcome that will ensure that that banks will trust clients and people will trust each other? Was there some cheating here? That's why we criminalize fraud. Because we want to create a society that is friendly and people don't cheat each other. So we suddenly get a different framework of analysis of this case. And then you'll find that the judges agree more and disagree less. Whereas earlier, many judges said bank should have it, this guy should have it. Now we ask a different question. We understand that this case involves actually a question of mutual relationships based on agreement, based on respecting the contract, respecting the and trusting the legal documents that were entered into. There was a good faith agreement and reliance on that agreement. That value has to be protected. What is the decision that will, I don't know enough of the facts, and frankly, that's a jury decision. I'm not interested in it. I'm interested only in the criteria that we will rely on to make that decision. I think the criteria, even in that case, I can apply this framework already and say, look, this is how you will resolve that framework. You will consider how this will enhance or damage between these people and the community and the nation at large, fraternity and fraternal relations with each other. So, so these are the 2 points that I've made so far. Understanding the Constitution as a project of establishing fraternity and friendly relations between the people of a very diverse, very different, and highly conflicted, highly unequal, very rich and very poor, very complex society. The only way we can stay together as India is through fraternity. And for that fraternity, To establish that fraternity, we know that conflict can be resolved only by elevating the conflicts and telling people that your conflict is going to be resolved with reference to highest level of 5 values, which are eternal values, and that you cannot and no reasonable person can reject. Let's apply those values and see how this conflict can be resolved, and then you'll be able to find solutions. And those set of eternal values is what we mean by justice, because justice is a benchmark, is the North Star about what is the right conduct, eternal right conduct that all human beings should follow. And therefore, when the Constitution of India says we are constituting India into a republic to secure to ourselves justice, social, economic, and political, what the Constitution means is that we are establishing a society in which social, economic, and political relationships shall be guided by justice, which means eternal values laid down in the Constitution, by the right values laid down in the Constitution, the highest values laid down in the Constitution. So justice means the values that are laid for us in the legal field, the values of human conduct that are laid down in the Constitution. So we've done those two things. We can come back and then we will tackle the methodology, the conceptual methodology of doing this in terms of the other values that we talked about, which is rule of law and reasoning. That's very important. Yes, sir.
Sir,
shall we take a break?
Sir, yes, sir. Before taking the break, I would like to put up a related question.
Yes, sir.
Since, sir, you have dealt with the concept of justice and about to go into the concept of law also now.
Rule of law.
Rule of law. Yes, sir.
Yes.
And
reason.
Sir, maybe a related query, sir. One honorable justice from Sri Lanka put
Yes,
it like this. Put it like this. Justice and law always are not same. Justice and law always are not same.
Yes. Yes.
People mostly look for justice, but not for law.
Yes.
But they want justice based on law.
Yes.
So how to balance this?
That is exactly what the fundamental force, which we call rule of law, that keeps our judicial system in the air. That's exactly what the concept of rule of law and reasoning do, sir. So we'll come back. Thank you, sir, Justice from Sri Lanka, for this wonderful question that gives us a perfect transition to the session, last part of the session for today when we come back.
I appeal to all the participants not to disconnect. Please continue the connectivity. But one more appeal is that those who have logged in anonymously, if they put the questions to enable us to take their name also, if you can log in this interval with your station followed by your name and designation, it will be helpful to all of us, sir. So with this request, sir, we will take 15 minutes break, sir.
Yes, sir.
So now it is say Chetan Singh, sir. What time we will start again?
So 12:10. If we give 15 minutes, so 12:10 we'll start back.
Sir,
should we take 15 minutes or 10 minutes, sir? Since we lost time, should we take 15? What is the feeling, sir? 15 minutes.
10 minutes will be okay.
Let
sir.
us reassemble at 10 o'clock and in 10 minutes at 12:10.
12:10. Okay.
So that'll be 12. That'll be 12:05.
12:05.
Sorry, 12:05. Okay.
That'll be 12:05.
12:05. That's correct. 12:05. Correct.
So you all meet in 10 minutes from now. That is 12.
Sir, it is not for the participants. It is for the speaker to have 5 more minutes, sir.
No, sir. I will reassemble at 12:05. We'll see. So between 12:05 and 12:10, we will begin, depending on how many people join.
Yes, sir. Thank you, sir.
Thank you very much.
Welcome once again, Dr. Mohan Gopal sir. I would request you to resume the session, sir.
Yes, thank you very much. Perhaps you can share one or two questions with me if people are not back.
Sir.
Yes, sir.
Sir, can you give the name of that case, sir, of Justice Ravindra Bhatt, sir, or some facts?
Prithviraj Chauhan, sir. Prithviraj Chauhan.
Prithviraj Chauhan. So some participants were asking. Yes, sir.
Prithviraj Chauhan. February 2020, Supreme Court.
Sir, one question is, all judges adjudicating the matter are going to do the justice.
Yes.
Should the justice be the end result of the case?
Yes, yes, yes. Okay, so let's take that, sir. And very good question, sir. So, see, one point that is so simple that very sophisticated minds find it difficult to understand or accept is that justice simply means the standard of conduct, the norm that with which you say whether conduct is right or wrong, against which you say conduct is right or wrong. And I'll come that when we discuss law and justice, we will come a little back more to that. So at the end of the day, sir, the impact of a judicial decision must be that it upholds the right standard of conduct. It must be based, it must uphold the right standard of conduct. Then there is justice. When the judgment upholds and is enforced and human conduct changes from right to wrong, then we say there is justice. A judicial decision itself is not justice. When a judicial decision, along with many other factors, contributes to wrong conduct, anti-social conduct, anti-fraternal conduct, anti-constitutional values conduct being corrected, and when human conduct is aligned with the right constitutional values, the 5 values that I said, then we say there is justice. So you can say a judicial decision is just, but I will never say a judicial decision gives justice. It can be just because it upholds the right values, the constitutional values. So it's a just decision. But justice only is secured when actual human conduct is changed and is in line with human values. So judgment can contribute to justice. That is why we say, sir, promoting justice, securing justice. But judges say delivering justice. You cannot deliver justice unless you can contribute to secure justice, promote justice. So I don't know if that's clear, sir, what I'm saying.
Sir, yes, sir. Sir, a similar question, sir.
Yes, sir.
Justice is always complete. Is it correct to say complete justice? Are there any differences between justice and complete justice? Or we are just using this word as someone has used it somewhere?
No, sir, this, see, as you know better than me, sir, this word is now suddenly becoming more popular, sir. It was not so popular earlier. Because I've been involved in this business for, as I said, 17, 18 years. I'm finding that this is now becoming more popular. Sir, as you know, this word originates in Article 142, this phrase, complete justice.
Yes.
And in, sir, in Civil Procedure Code 151, it also, a similar provision, sir. Now, what it in Article 142 and in 151, it is meant to do justice between the parties inter se in a particular case. So what we are meaning is that do an order that will ensure that the behavior of the parties inter se to each other comes in line with the right values. And if there is something blocking that, then that block can be overcome. But now we will come, sir, to the difference between justice and law and rule of law. So maybe this will answer that question also, sir, or at least I'll give you my framework of that. So first of all, what is Honorable Justice from Sri Lanka asked, justice and law always are not the same. People look for justice, not law. They want justice, they look for justice, not law. And they want justice, but they want justice based on law. So isn't there a contradiction? So the way I understand it, sir, I'm not saying this is the right thing or for everybody, but my own understanding is we have to distinguish between the core concept of justice, as we have done, and the core concept of law. We have understood that the core concept of justice is that justice is a standard of human conduct. It's simply a statement of values. It's a benchmark. It's a what is the Hindi word for benchmark, sir?
Artho.
Hindi word for benchmark. In Malayalam, we say it's a Sanskrit word, mana dandam.
Yes, ma'am. Manak.
Manak.
Yes, sir.
It's a benchmark. So justice is a benchmark against which we measure whether our conduct is right or wrong. Right? And so if the conduct is right, we say, yeah, justice is prevailing because our conduct is now aligned with the concept of justice. So first thing we must understand is justice is simply a statement of right values. And conduct and justice prevails when human conduct is consistent with those values. What is law, sir? I would submit, and I'll say this very slowly because it's very, very simple and it's difficult for sophisticated people to understand simple ideas. Law is only it's a hypothetical fact pattern, sir. Hypothetical fact pattern. So when I take the Indian Penal Code and I randomly open it to section 203, giving false information respecting an offence committed. Whoever, knowing or having reason to believe that an offence has been committed, gives any information respecting that offence which he knows or believes to be false. It's a hypothetical fact pattern, sir. Shall be punished with imprisonment. So the law is laying down a hypothetical fact pattern and saying this shall not happen. If it happens, there will be consequences. Now, this hypothetical fact pattern is laid down as a rule in order to uphold, to give guidance to humans on how you should behave so that the higher values of justice are protected. So if in my family, for example, I say to my children that look, you must behave in a friendly way towards everyone. We must respect everyone's dignity. That is the value of dignity is the high value. Then I set out a rule that you shall not address the staff in the house as tu. So that's a hypothetical fact pattern. I'm saying, look, that fact pattern cannot occur. But that fact pattern is actually meant to uphold a higher value. Now, suppose that person does not say tu, but uses a Malayalam word for tu, like ni. and then tells me, but your rule said I should not use tu, but I have used the Malayalam word ni. Then I will say, I have to interpret that rule to uphold the value which you know, that you shall respect the dignity of everyone. And you, whether you use ni or you use tu, I will interpret it as a violation, because it is in substance the same. Because if I say you can use ni, because in the rule I did not specify ni, then the value that I'm seeking to uphold through that rule gets defeated. And a man is insulted and there is no consequence. And that man will think, in this house, there is no respect for the staff. I am not called tu, but I am called ni. Right? Now, so therefore, we must understand the relationship between the principle of, or the value of conduct, which is broad, and the specific rules that are set up in law to ensure that those values are upheld, the fact patterns that are laid down. So this is like a pilot being told that, look, when you take off, you cannot take off at an angle that is sharper than this, because gravity will pull you down. So if you go completely vertical, you can see on YouTube, if the weight is wrong and the angle is sharp, the plane will just come down like a piece of metal, crashing to the ground. Now, if I specify some cargo weight, but I don't specify passenger weight, and he says, no, but you didn't specify that, then I'll say, no, but you know the principle. The force that I'm upholding here is, I'm telling you, don't violate gravity. Now, you should have the training, you have the good sense to understand that gravity has to be respected. Now, my rules may or may not cover all the fact patterns where gravity has to be respected. But you must know that your ultimate obligation is never violate gravity, because your plane will crash. So use your discretion, use your interpretative power, be creative, which is why I call it the art, science, and craft of judging, but never violate these fundamental forces, because you will crash. And therefore, when we say we want justice, what we are saying is we want the highest law to be upheld, highest principles to be upheld. Sometimes when judges say that, okay, let me give you another example, sir. Suppose I use that example with someone else. Suppose a little boy is running around in my house, my son. I'm too old to have a little boy as a son, but long ago. And I tell the little boy, stop running. Now, there are two sets of underlying reasons why I may be saying that. One reason is that I'm just very selfish. I'm irritated by the boy running up and down. I just want to be quiet. And I'm telling him, don't disturb me. When I know that little boys and girls need to run, they need to run around, and they need to make noise, that's how they grow. There's nothing wrong with that. But I should go and sit somewhere else, or I should be tolerant to it. I should not assert the value of selfishness. The other alternative is, let's say that the floor and the area is very slippery, it's very dangerous. And if that is the case, then I'm upholding a value of safety. Don't do something risky and unsafe. Don't do something risky and unsafe. And that is a value worth. And then he tells me, okay, you told me not to run on this floor, but I ran on the other floor and I fell. Then I should explain to him that, look, the rule that you should not run fast does not apply. I said, yes, don't run fast here, but I meant don't run fast in any slippery floor, because you will fall. So sometimes, sir, the rule is adequate in and by itself to uphold the higher value. Sometimes it is not clear that what is the higher value that it is supposed to uphold. It may be a wrong rule, appears to be neutral. It can be used to uphold the wrong value and the right value. And the third is that it supports the right value, but it requires some interpretation. So this is where judicial interpretation, practical situations come in. If you keep in mind the higher constitutional value that is to be advanced, promoted in every case, then you can see whether in the case before you, there is a clear hypothetical fact pattern, namely a law, that clearly and directly advances that value. No problem, just apply it. Or other opposite end, that there is clearly a rule that is sought to be applied in a particular case to uphold the wrong value. And we'll come to it in the case tomorrow, sir, where one of the session judges in Delhi, we'll discuss tomorrow, gave bail to a woman who is accused in a case where her sister-in-law was committed suicide, and there was dowry harassment and so on and so forth. He gave bail to her, right? So it's a serious offense. So the question is, what is the underlying value that application for bail and the grant of bail, what is the underlying value that it actually upholds? Does it actually confuse people that even if you do something heinous that results in in dowry harassment and results in a young woman having to kill herself, you'll still get bail? Or is there some other value? So the law, it's a sessions judge, sir. So sessions, as you know, sir, 439, all of you sessions judges and high court judges, you have very broad power to grant bail. But when you grant bail, you have to consider what is the value of conduct that I'm going to be endorsing by granting bail or by denying bail. What is the standard of conduct, the value of conduct that I will be protecting and advancing, promoting? So that's a second situation, the extreme situation where the rule may allow you to do something which actually damages the desired value, then you can't do it. The third situation is where you can interpret the rule in a way that advances, like I said, you say tu or you say ni, you should respect all the staff here. You cannot disrespect people because people have equal dignity. So if I interpret it in such a way that advances that concept, then I'm upholding that concept. So justice and law may work against each other because there may be hypothetical fact patterns or laws that actually, in a particular context, adversely affect the larger principle which is part of justice, or law can support those larger principles, but ultimately we cannot have a situation where a hypothetical fact pattern, a law, is applied to a fact pattern in facts of a particular case in order to damage the values that are sacred in the Constitution, sir, the eternal values. For example, in that case you raised at the beginning, the banking case, we cannot have the application result in damaging the values of fraternity and trust. Those are values we have to safeguard. So then we have to figure out how do we interpret the law to uphold those values. So justice and law must be aligned, must go together. The fact patterns must be interpreted and interpret. Now, this is the advice that a judge would give the jury. The judge will interpret the law to the jury and say, you must read the law in this context, in this manner, because that interpretation upholds justice. And you should tell the jury that you should not. And we will see that tomorrow, sir, how the judge advises the jury on how to understand and interpret the law in a manner that upholds the values of justice. So I think, sir, it is entirely in the hands of the judge whether law and justice conflict with each other or are complementary to each other. They must be interpreted, jusdem generis, in a harmonious manner. And I think that, but you cannot do justice unless there is a legal basis. The law also provides the power to act. So that brings us straight to the next topic, the last but one topic, which is rule of law. Very, very widely discussed concept. Everybody speaks about it. Huge volumes of material and books written on it. But very much yourself, Mr. Judeja, and the Delhi Judicial Academy have been giving it importance. But a lot of the academies are not delving into it as seriously as they should, because it is a concept that is directly the responsibility of the judge, sir. Directly the responsibility of the judge. Because the most commonly accepted kind of dictionary definition, if you look at the dictionary, the rule of law, like all of you know, it is the restriction of arbitrary exercise of power. By subordinating power to established law. So the purpose is to take away subjectivity, sir. To take away subjectivity. So the concept of the rule of law, the real purpose of the concept of the rule of law is that we are ruled by law, not by persons. And so the arbitrary power. So discretion cannot be exercised in an arbitrary manner. That would violate the rule of law. No action can be taken without an authorization of power, of jurisdiction and power. So that is why we say, sir, values must be upheld, that is, justice must be upheld, but based on law. By those who have been granted power by the democratic legislature to do so. And that is a relationship also between justice and law. Law gives the authority for action. Justice gives the reason for action. Which is to uphold right values of human conduct. Any questions, sir, on that you might want to? I don't like giving a monologue, sir, but
sir, for those who might have joined late, only one statement they want. Can you please repeat the 5 values mentioned? The law, justice, democracy, reasoning.
Not law, sir. Rule of law, sir. Not
concepts.
Law, sir.
Yes, sir. Rule of law.
Sir, I will. Yes, sir. I will start with Constitution.
Sir.
And then I will. Number 2 is justice. So, number 3, I would say, as in the order in which I'm going, sir, is rule of law, which includes the concept of law. Rule of law is rule of law, rule based on law, law-based rule is better. The Chinese government uses rule by law, sir. So they say they can do anything they want as long as there is a law. That is rule by law. But we say rule-based and just law. That means that law that advances the eternal values, sthayi mulya of the Constitution. Whereas the Chinese don't accept generally this second part. If there is law, there is authority, you do what you want, rule by law. But implicit in rule of law, sir, rule of law is a vaccine against personal power, which is fatal, sir. Personal power is fatal. It is like a plane suddenly not having the airflow, sir, to support it. It will crash. It will crash. So the biggest enemy of democratic justice is personal power. Personal power. So every time a judge thinks that I have given something to this person out of my quote unquote mercy and compassion, that's a grave violation of the rule of law, sir. That mercy and compassion has to be established within the Constitution, within the law, within principles of law, so that No matter who sits in that chair, that mercy will continue. We can't have a merciful judge, sir. We want to have a merciful chair of the judge, as a symbol of the art, craft and science of judging, the process of judging. And so the rule of law, sir, is a technology. It is a vaccine against individual power. And it is not, sir, that the judge is the doctor that must give the injections against arbitrariness by others. I was telling Honorable Judge I spoke to this morning that, look, actually, a judge is not arresting, a judge is not giving bail, actually. Bail is only freedom from arrest, but executive is arresting. And bail is simply an audit by the judge on whether that arrest is just or unjust, is based on legal authority or not. And when the judge feels that an arrest is not justified according to the use, has no support in the use of the Constitution, then the judge says, no, you cannot arrest, and the person gets bail. Judges, as famously said, as neither purse nor sword. Judge is an auditor. It's like a school inspector, sir. School inspector comes to a school. School inspector doesn't teach. But school inspector tells a teacher, you cannot treat children like this. You cannot treat children like this. So when you give bail, you're telling the state, you cannot treat people like this. It is against the constitutional idea of fraternity. Because, sir, beneath all these institutions, we are human beings who are acting against each other, sir, not institutions and not some machines. Every single person in jail in India today for and in police custody for longer than 24 hours has been put there by a human being who's called a judge. And the others have been put there by human beings called police officers. Now, what Justice Butt tells us is that we have an agreement on how we should treat each other. And the auditor, this guardian of that agreement, is a judge. And the judge says, sorry, this is not how Indians should treat each other. Just throw somebody in some jail, die of COVID. That is not how we should treat each other. But on the other hand, if the law has laid down that you have acted in a way that violates fraternal conduct, you've murdered somebody, you're still antisocial, violent towards others, COVID or no COVID, friendly conduct has to be protected. Yesterday, I got a circular from my housing society in Delhi saying they said we are not yet naming him, but there is one person in our housing society who is just going around creating problems, fighting with people, doing this, doing that. What are they saying, sir? If that was the country, the community is saying, restrain this unfriendly conduct. So the society is appealing to everybody. Please talk to him and tell him not to be friendly, because we have to live together in a society. So the judge is an auditor to make sure that Indians treat each other properly, sir. You're not arresting anyone. You're not sending anyone to jail even after conviction and punishment, sir. The people of this country have decided that, in the example I read out to you, if you have given false information, that's very wrong. You're actually damaging somebody else. You are implementing that norm and upholding fraternal conduct. That this is not fraternal conduct. This is inimical conduct. This is unfraternal conduct. We cannot support this. So therefore, sir, we must understand that the role of the judge is not to settle dispute. Of course, in the process, disputes may get settled. Sometimes it may get exacerbated. But the judge is Judge is not mediator or arbitrator. It's not a dispute settlement entity. Judge is declaring what is the use. DECIRE means declare, decide the use, the right value of conduct. The judge is telling people, you have behaved in this way. You disagree on what is the right conduct. I am the auditor of bad conduct and right conduct. I'm telling you this is like the school inspector. I'm telling you this is the right way to behave. So the job of the judge is to uphold right conduct, sir. That is use decere. Decere means decide, means uphold, to uphold use. That's the job of the judge. And for that, sir, the judge, as I said, must interpret law in that way. And when others behave in the wrong way, violate the rule of law, behave in an arbitrary manner, use personal power, the judge is the one, the last resort for people to come to and say, please restrain wrong conduct by executive, by legislature, by private sector, whoever. And the judge must be clear in his or her mind about what is right conduct and what is wrong conduct and how I can effectively correct it and ensure the right conduct prevails. And until and unless the right conduct prevails, you have not done justice.
Sir, I may be allowed to put small 3 questions, sir.
Yes, sir. Yes, sir. Sir, I didn't complete the list, sir. I've completed the list, sir. Just rule of law, reasoning. Yes, and then I'm also putting in it, sir, plus one compassion. Plus one compassion. That is just my addition, sir. Plus one compassion, which I see it in the Constitution. Sir, when I talk to non-lawyers, which I do sometimes on the Constitution, I hold this book up, sir, and I say, this is a book of compassion. It is trying to create a friendly society in this very diverse and conflicted and unequal country, based on 4 simple values, 5 simple values. If we all accept those values and practice those values, we will succeed in establishing justice amongst us. But this is just a guide to us, a mandatory guide. If you violate it, you're going to be in trouble. But it is basically showing it's showing us the right path. So these 5 values, sir. 5 forces, the physics of the judicial system, sir. The physics of justice. 5 forces: constitution, justice, rule of law, reasoning, and compassion.
Sir, since you referred to compassion, yes, I may be allowed to take up the question of Justice Kulatunga from Sri Lanka on the point of compassion.
Yes, sir.
Would compassion focus on the decision and deviate from following the correct procedure and the 5 principles?
Yes, sir. Very good question, and I'll answer it, sir. If you read if Honorable Judge may have already read it, you may have read it. If you have not, if you refer to a small booklet called The Common Law, written by Justice Oliver Wendell Holmes a long time ago, he explains, sir, the evolution of criminal law from individual justice to collective justice. So originally, if somebody did a crime against you, then you could take personal vengeance against that person, and society would accept that. But gradually we moved away from that because society was full of people running around killing each other, for personal revenge. So they said this has got to stop. So they said, okay, some wrong is done to you. Society on your behalf will collectively bring to justice, to the right conduct. Justice means right conduct. Will bring to the right conduct, constitution, the right conduct, the wrongdoer. Took away the personal right to seek justice. Similarly, sir, when I talk of compassion, I'm talking about compassion as constitutionalized in the Constitution. Not compassion that I feel, but I feel through the Constitution, as a scholar of the Constitution. The pain of the citizen must become the pain of the Constitution, as I see it. And from that Constitution, I must feel that pain. So if you read the Constitution as a whole, and you understand it For example, in part 4 of the Constitution, part 3 of the Constitution, there is all of this is meant to avoid pain and create friendly relationship. Take the right to residence, the right to movement, the right to employment, the right to education. These are all fundamental rights. The right to religion, the right to freedom of conscience. These are all fundamental rights. The right to social justice, the right to equality, which includes 15, 16, 17, and 18. 15 is the right against discrimination. 14 is the general right to equality. 15 is the right against discrimination. 16 is the right to reservation and right to equal opportunity in matters of public employment. 17 is right against untouchability. 18 is right against title. Right? That not right against the prohibition of titles. So you'll find that every provision in the Constitution is reflecting compassion towards the powerless in a deeply divided society, in a deeply hierarchical society, in a deeply unjust society, where these values, sir, actually there is a big war going on between the values of the elites, which are not, we do not accept fraternity, but accept demand obedience and loyalty, not fraternity. Do not accept equality, but accept hierarchy. Do not accept dignity, but accept humiliation. Do not accept democracy, but accept monarchy. And technocracy and in meritocracy. So we have a very powerful elite who are not accepting the values of this Constitution, which are highly democratic, reflect the values of the poor people of this country and the national freedom struggle. And so there is actually a Mahabharata going on between these sets of values. So when you talked about social justice, the word social comes from the word socius. So justice that promotes friendly conflict conduct is justice, sir. That promotes and that requires the powerful to give space to the powerless, not the powerless to continue to give space to the powerful, to bring about equality, to bring about fraternity. So all of these elements are social justice. And economic and political justice requires that the economy and the political system must further the idea of fraternity, Ultimate value, sir, as Justice Bhatt argues. And separately, before he became a judge, Justice Rohinton Nariman had also given a very important speech, sir. And I think he's written about it after he's become a judge also. But the centrality of this neglected idea of fraternity as the core, that's natural, sir. In diverse country, core objective of the Constitution is to establish fraternity. So social justice is very essential for that. Social justice means justice that will promote fraternity and equality and liberty and freedom, central to the idea of justice. So I would say, sir, that compassion, we mean compassion as channeled through the framework of the Constitution so that it becomes consistent. So the Constitution has wonderful provisions, sir, and we have got some very good pieces of law like the Protection of Women Against Domestic Violence Act, which is one of the first pieces of law that actually criminalizes violence inside the house. Article 38(1) says all institutions of national life must be informed by justice, social, economic, and political, and that includes family as a key institution of national life. So we have legislation, we have constitutional provisions that all explicitly and indirectly, and tomorrow we'll see, sir, how the Sessions Court judge has given a very compassionate judgment by internalizing, going through law, not that he says, I feel I must give mercy or compassion, but says there is this, he doesn't use the word compassion, but he says there is this document, this law, these laws that we must implement in order to uphold justice. So I would say, sir, that we, like criminal justice and punishment, we have to, in order to get consistency, we must institutionalize more and more through judicial judgments, through legislation, And judicial interpretation, not judicial legislation, judicial interpretation and legislation, we must institutionalize compassion.
Sir, may I put two small questions before you can continue with this?
Yes, sir. I need to do reasoning, sir. Yeah, I need to finish reasoning before 1 o'clock, sir. Yes.
Yes, sir. Sir, the question is from Justice Narhari, officer from the Nepal Judicial Service.
Yes, sir.
How does the political questions deal in sub judice cases to try under given 5 basic features of securing justice? How does the political questions deal in sub judice cases to try under given 5 basic features of the securing justice?
Yes. Yes. I think we will, very good question to move to reasoning, sir, because this comes as this is a methodological question, and tomorrow we get into this issue more deeply in the context of 2 live cases, sir, 2 actual cases. Today we are only exploring concepts. Tomorrow we will apply these concepts in real cases. Sir, this brings us to the issue of reasoning, sir. Sir, here there are three words, and I'll answer this Honorable Justice's question at the end of this, sir, very shortly. There are 3 basic concepts that we have to bear in mind when we talk of reasoning. First of all, as a concept, what is reasoning, sir? Reason is, the dictionary meaning of reason is a number of meanings, sir. It is why you do something, what drives something, what motivates something, what is the nimitta or the hetu, or the why something happens. That is the reason, simple meaning. But reason is different from reasoning. Reasoning is actually has evolved to become a particular technique of questioning why human action takes place. And it has become very important. It emerged in science and then has come from science to law. And so it's a method of thinking, sir. It's a method of thinking. Reasoning is a method of thinking. It's a technology of thinking. And it has, there's a lot, we can get into it a little more tomorrow also, but it's a methodology of thinking. And as everyone knows, there's deductive thinking, there is inductive thinking, there are different types of thinking, but these are all different techniques of thinking. Now, in legal reasoning, sir, what is the most important point? So reasoning is simply a method of thinking, a technology of thinking with which we can use to question whether reasons are right or wrong. Now, what is legal reasoning? So legal reasoning is the methods of thinking used in law, usually by courts, to decide the questions before the court. Now, central to legal reasoning is the adversarial system for us, and the plea and the arguments being put by the 2 parties. So the idea of argument is very central to us in approach to reasoning. Everything must be put forward as a plea or an argument. Am I right or wrong, sir? Am I missing something, sir? Am I right or wrong?
Yes, sir.
Yes, sir. So in which case, the question is, what is argument, sir? So an argument is basically a structured description of a relationship, or one or more relationships between one or more things. An argument is a description, a structured description about how something is related to something else. Usually, as we know, the argument has some premises, which are some facts, and then it leads to a conclusion based on those premises. And the argument, the relationship between the elements that constitute an argument. Remember, I'm submitting reasoning is a method of thinking. And this is now, the method of thinking is what I'm describing in legal reasoning. It starts with an argument. An argument is is arguing, or is proposing, or makes the proposition that there is a relationship between some things, facts, objects, whatever. There's a relationship. Now this relationship must be logical. Logical. The things that we are talking about, sir, must be factual. We know the definition of fact in the Indian Evidence Act. Beautiful definition of fact. That which exists, right, sir? Or a reasonable person would act on the assumption that it exists, which is observable by the material senses, or is a state of mind. Proved fact is what I'm saying, proved fact, combining the definition of fact and proved fact. A fact is something that exists, is observable by the material senses, or is a state of mind. So an argument in law must put forward the proposition that there is a relationship between facts. And that relationship must be based on logic, must be logical. So what is logic? Basically, logic means that relationship is supported by some existing theory or system. For example, I traveled by air, somebody sitting next to me was COVID positive, and therefore I contracted COVID. I'm able to make this argument because there's a theory that COVID is transmitted by droplets or by air, and if I sit next to someone who's COVID positive, there's a good chance I could get it. But I cannot say that I sat next to someone on a plane and I got infected by his intelligence and his knowledge. Because there is no theory that says that if I sit next to somebody, I will get infected by his knowledge and his intelligence unless he speaks to me. So I sat next to someone, he never spoke to me, never communicated with me, and he infected me with this intelligence and knowledge. Not possible. There is no theory. So logic is an argument, evidence that of the relationship. That there is a basis for saying there's a relationship. And that evidence is based on a scientific system that makes it truthful. So Christians sometimes say, in the name of the Father, the Son, and the Holy Ghost, Amen. So some of them say, in the name of the Father and the Son and the Word, Amen. Instead of the Holy Ghost, they say the Word. They consider the Word as sacred because the word is used to refer to the truth, to God, to the truth. So logos means the word. So logical means truthful. So an argument must show there's a relationship between some facts. That relationship must be logical, means it must be basically truthful, either directly observable or because there is a system, there's a theory. So I can say with credibility to a court that the airline put me next to a COVID infected positive person and I got COVID. Because there's a theory to support on the theory of transmission of COVID. But as I said, I cannot say he infected me. If I go to a judge and say, Sir, Mr. Yaralagada, Your Honor, Your Lordship, this man infected me with this infection, his intelligence, because I sat next to him. You'll ask, did he talk to you? No. Did he write anything to you? No. Did he signal anything to you? No. Did he look at you? No. Then how can he infect you with his knowledge or infect? There is no theory on how it can happen. So this is the logical connection. Now this together, logical arguments based on facts, and there we consider law also as a type of law, facts. That's why I said it's a set of hypothetical facts, legal principles. So if you connect physical facts, mental facts, the existence of law, which is an idea. Law is only an idea, sir. It's a fiction of our mind. It doesn't exist. It exists only in our imagination. The Constitution, these are just half emotion, half idea that exists in our brain, so that we'll be good to each other. So if I say there are mental states, law, I can recognize ideas, mental states, physical things, all these relationships are there, and I can show that the argument is logical, namely based on truth. Then, sir, this logic will lead to its own conclusion. Its own conclusion. Because a coconut tree cannot ripen like a mango. Coconut tree cannot produce a mango. Coconut cannot ripen like a mango. So when you say, I saw a coconut tree, mangoes on a coconut tree, the logic breaks down. But if I say I saw coconuts on a coconut tree, okay, next step. So when you follow the path of the argument, makes a proposition of relationships based on truth, it leads to its own conclusion, sir. It leads to its own conclusion, provided it is done rigorously, not subjectively. Therefore, if a matter is sub judice or not sub judice, the greatest friend of the judge and the lawyer is argument and logic. These five forces, sir, they keep, like the plane is kept in the air, safe by the four forces of lift and thrust and drag and weight. By a combination of these four forces, the plane of justice is kept afloat by these five forces, four plus one forces. The Constitution, as setting out the fundamental norms that should govern a society which should be fraternal to each other. The justice laying down specifically the values of conduct that should be required in a fraternal society. The rule of law and reasoning as a methodology to ensure that decisions affecting each other are not made arbitrarily by individuals. That would destroy friendly society, lead to corruption. That arbitrary power is restrained. And subordinated to these principles. So that these principles, which are all intended to create fraternity and a friendly society, are all upheld and protected, so that at the end of the day we have a society in which justice prevails, means human conduct is in line with these values, and then we'll have a friendly and fraternal society. When this technology of rule of law and reasoning is followed, then the judge becomes extremely strong, sir. When the judge's reasoning is weak, argumentation is weak, logic is weak, understanding of justice is weak, understanding of the Constitution is limited, then that judge actually becomes very vulnerable. That lawyer becomes very vulnerable. You know this as a judge. If I stand there before you as a lawyer, actually I'm making an argument now, sir, before you, before all these judges. I'm making an argument. I'm actually like a lawyer in court. I'm making an argument to you, which you're considering, you may accept or reject. I'm arguing to you, based on judicial precedent, that the Constitution is a compact and agreement between people on establishing fraternity. And I'm arguing to you that justice is a set of values that will guarantee a fraternal society. I'm arguing to you that a fraternal society cannot be established when there is arbitrariness and personal and subjective rule, and therefore we need the rule of law to ensure that law is interpreted and laid down. Hypothetical sets of facts are laid down to uphold these values, which will lead to a fraternal society, and that this application of the craft of application of law to find facts and apply law to to facts is separate, but to interpret the law, to give the law. What is the law that governs the decision of the banking situation, for example, that dispute that you talked about? That craft is developed through reasoning based on legal arguments, which are logical and fact-based, and following structures of reasoning, deductive, inductive, that are also following well-established principles of thinking. Reason is established principles of thinking about law, thinking about justice, thinking about your decision. So our thinking processes as lawyers and judges has to be disciplined by established procedures of thinking, established systems of thinking, established norms of thinking. We cannot think from our conscience. The conscience is an empty place, sir. It is simply a faculty we have, a function we have of questioning ourselves. It's empty. But our conscience, personal conscience, has no place in judicial decision making or in jury decision making, as we will see tomorrow in those instructions. We have to apply, we have to find the law and interpret the law in accordance with well-established principles of reasoning based on logic. Now I'm reversing the process. In order to, based on authority given by law and within the constraints of law, to uphold the values prescribed, the eternal values prescribed in the Constitution as justice, in order to finally have fraternity in our society, by having a society that accepts equality, liberty, fraternity, and dignity. This is the reverse order of this. Now, the craft we will tomorrow go a little bit more. Tomorrow we'll go a little more into reasoning and logic, sir, because we are now coming to application. We understand that the purpose of all this exercise is to establish fraternity based on equality, liberty, not fraternity based on feudal ideas of obedience and subservience. There also you can have false fraternity, but we want a fraternity of free people and equal people, people with dignity. And so we have understood, or I've submitted to you, that this is the purpose of securing justice. And the methodology of securing justice is what we will get into more deeply tomorrow. This is reasoning and logic and the rule of law. And as I said, that is like comparing to the aircraft, sir, that the air provides the lift, the thrust moves it forward, but ultimately it is the deep understanding of gravity which is pulling it down, counterweights against justice. Gravity is pulling it down, sir. And drag is pushing it back. So the pilot has to manage drag and gravity to ensure that the aircraft doesn't crash. Similarly, sir, reasoning and the rule of law are instruments given to the pilots of justice to manage the forces that are pulling, of injustice that are pulling it down. As the Honorable Judge said, political pressure, personal pressure, careerism, corruption, all these things that are pulling us down. These have to be countered through and neutralized through reasoning, rule of law and reasoning. And ultimately, sir, compassion merges with the idea of fraternity, because you cannot have fraternity without compassion, sir. You cannot have fraternity without compassion. In fact, at the root and heart of fraternity is compassion, that the highest friend, the greatest friend is a friend who feels your pain, sir. And therefore, I would not put it as a separate item, but I would merge it, although we need to remember it, and we'll remember it tomorrow. So shall I stop here, sir? It's 5 minutes past 1 o'clock.
Yes, sir.
If it's a logical point to stop.
Yes, sir.
So tomorrow, sir, what we will do is we will apply some of these concepts and find them in two cases, sir. Two instances. One is the recent murder of George Floyd in Minnesota by a policeman and the trial that took place. We won't get into the whole trial. We will look at the instructions to the jury, And if anyone is interested today, they can go to the net and search for it. You'll find it and read it. If not, I'll try and display it. And the other is a very interesting, very important for me, judgment, a bail order of a Delhi Sessions Court. And we'll see how, through rule of law and reasoning, in these two practical applications, these ideas, values of justice, and the goals of fraternity are being protected and in practical terms.
Sir, may I make one request?
Sir.
I would request my co-host Chetan Singh to email the questions to you as well as me, which we have received, so that we can have a cursory look and take up covered to cover, if as far as possible can be covered tomorrow.
Very helpful, sir.
Sir, the charts are available, sir. Please, with the kind permission of the guest speaker, we are concluding session for today. I express my thanks to the guest speaker. Once again, I tender my apology for the delay in getting the connection today. Sir has.
If I may, sir, could we guarantee the honorable judges who are taking their very precious time to be here, for which I'm very grateful, that tomorrow we will start promptly at 10, and we can start at 8 o'clock in the morning getting in, sir, but let us start at 10. Today I started at around 9:45, 9:40, but it was too late. But let us guarantee that tomorrow we will be on time, sir.
Yes. Today, I express my gratitude to all the participants who have posted their queries and made this session a very lively one. And I express my thanks to my co-host, SCC Online, Chetan Singh, Sanjay Kapoor, and all the honorable judges and the participants. Tomorrow we will again meet at 10 o'clock without any delay. For today, thank you very much.
Thank you, sir.
Thank you, sir. Thank you. So we end this webinar now.
Yes, please.
On the WhatsApp.